Well, I'm tuning up, and it's time for you to tune up too. On week number 5, we're going to talk about sales and lease contracts. Now, sales law is uh, a part of common law contracts, so you have to understand common law contracts and the 4 basic elements that we talked about, those being capacity, the agreement itself, offer and acceptance. It's got to be a legal deal, and you have to have consideration. Now, in addition, sales contracts are impacted by the Uniform Commercial Code, the UCC. This is a massive body of law that is adopted by every state, and it's unfortunately doesn't cover all commercial transactions, and it's not uniform, so it's clear as mud. But I'm going to make it easy for you. First, make sure when you're looking at a contract, you make a determination whether it's a sales contract, sale of goods. The UCC Article 2, you'll see in your book and in the appendix, defines what a good is. Basically, it's anything that's movable, but it could be unborn animals, crops, things like that. So there's some weird exceptions. Service contract, think of an employment contract. If you have an employment contract, you're not concerned with the Uniform Commercial Code. So the Uniform Commercial Code, the objective there is to make sales and commercial transactions easier by ameliorating some of the restrictions that are present in common law contracts. Specifically, for example, with the offer in a sales contract, the offer can be doesn't need to be definite. You can buy goods where the contract says market price. In an employment contract, that's not going to work. Although you could have remedies like promissory estoppel or a quasi-contract under those circumstances. So keep those differences in mind. Again, statute of frauds with the UCC sales law of sales under the UCC is 4 years. You can reduce that to 1 year in the written agreement. It's important to understand that the UCC is essentially a default. So if you haven't covered it in your sales contract, this Uniform Commercial Code steps in to fill the gaps that you haven't addressed. Some things you can't waive, like good faith, things like that. When title and risk of loss passes, make sure you read that. This is not the same as in contract law. This includes like shipment contracts. If you contract to buy goods and they're shipped to you, and unless you specify otherwise, you're responsible for any risk of loss over the shipment. Lastly, I have here for you this distinction between the UCC and the contracts for the international sales of goods. If you're going to get involved with international sales, pay attention to that. Your book has more details on it. Plus, I have some great videos. So I'm going to grab my clicker here and tell you more about that right now. All right. The buyer and seller, they have different duties. The expectation is they're going to act in good faith. That the buyer is going to tender the seller is going to tender what the buyer wants. There are a number of peculiar exceptions that you need to pay attention to, and there's a resource I have on that I'll show you momentarily that really helps distinguish between common law contracts and sales contracts. But one of the things to keep in mind is not only to identify if it's a sales or service contract, but up front determine if you've got a merchant involved. Merchant is defined in the Uniform Commercial Code. There are options available for the non-breaching party. If the other party repudiates the contract, the thing is you've got to mitigate your losses. So there are certain terms you'll see that are used in the Uniform Commercial Code that the seller can cure the problem, the word cure, and that the buyer must cover, that means mitigate their losses. One of the big reasons that we have this distinction that's available to consumers are warranties. And you'll see your book talks about express implied warranties. The biggie is implied warranty of merchantability. If a merchant sells a good, there's an implication it's going to be fit for the purpose for which it's sold. There's also an implied warranty of fitness for a particular purpose, so it's a little confusing. But the implied warranty of merchantability, you see these when you buy a used car. The idea is the ID. You'll see as is, that's intended to waive that warranties. So these warranties, for the most part, can be waived, but the waiver has to be expressed. So you'll see that as well. So understand that the restatement of contracts refers to common law contracts, and there's a great video on this. But that's the terms we have already talked about, where the offer has to be very precise, definite, etc. Under the UCC, lots of loosening up of those criteria that help facilitate sales. I've already talked to you a little bit about the different types of warranties. I did want to emphasize here that the Uniform Commercial Code applies to all sales by merchants and non-merchants. So keep that in mind. There are special rules for merchants, very peculiar rules that you'll see, like firm offer, where if a seller or buyer puts in writing and signs at the beginning where the offer is made, that's enforceable even though there isn't any consideration or the rest of the contract isn't completed. So that is sales and lease